Good afternoon, everyone. Welcome to the Brooks Pierce webinar about coronavirus and employment issues. I want to thank you for being here. I'm going to introduce my colleague and I. We are two of the labor and employment attorneys here at Brooks Pierce who have been working through these issues since the beginning with various employers. I'm Natalie Sanders, and my colleague James Bobbitt is with me. We're going to present for you today some information about what we've been getting asked on all of this, some of the common questions, and we're going to go through those. Then we're going to talk about some of the new laws in place, the Families First Coronavirus Response Act, which goes into effect tomorrow. And then we'll pull a few pieces from the CARES Act that has been enacted, but we haven't seen a lot of guidance on yet. And then we're going to open it up for questions. We're going to try to leave a pretty good chunk at the end so that you can ask us what's on your minds, what issues you're seeing. So we're going to get started. But the first few slides, we're going to skip through. There's some background information about COVID-19, where we are, kind of some definitions, common ground for us. But I think we're past that at this point. We are going to make these slides available to you, so we wanted to leave it in there in case you needed it as a reference, but we're going to jump right on through those. Instead, we're going to start here about your response plans and what you're doing. Really, a lot of it comes down to looking at your internal policies. What do you have in place that applies now? And how can you be flexible and change that to adapt to what is going on? You probably have a lot of absences. You may have closures. We've got all these stay-home orders. There's a lot going on. You probably have gotten introduced to working remotely in a much bigger way than ever before. So there's a lot going on. We recognize that, and you've probably gone through what you have in place now. The key is doing it in the context of the laws that are applicable. And there are all of the usual laws in place that we need to think about. The Americans with Disabilities Act, Title VII, Family and Medical Leave Act, OSHA, the National Labor Relations Act. A lot of these come into play when you're talking about making inquiries of your employees about their symptoms and whether it's appropriate for them to be in the workplace or not. You've got the Americans with Disabilities Act in play. There are a lot of employers now that are taking temperatures of employees. That's a medical exam under the ADA, so there's a lot that has to be considered there. Title VII, there is surprisingly a lot of concern about how we're treating people based on their national origin in this time. Because the virus originated in China, we're seeing some misinformation out there. We just are really encouraging employers to make sure that they're encouraging their employees to treat each other respectfully and don't target people because of a national origin or background. Family and medical leave, that's definitely in play if you've got over the 50 employees, because it's very likely that if someone gets the coronavirus and there's any sort of complication, that's going to be a serious health condition under the FMLA, or perhaps a child or someone they're responsible for caring for. Those issues could come up. And of course, then there's the interplay between the regular Family and Medical Leave Act and the new leave laws. OSHA and the National Labor Relations Act are coming into play a lot with respect to employees who are concerned about coming to work. Is it a safe place to be? And we have some protections under both of those acts, and we have some guidance as well. So those are the issues that are out there that we're trying to encourage everyone to be aware of and spot as they're going through all of these. But before we talk about the new laws and things, we're going to just go ahead and jump right into what we have been getting as questions from people. And I'm going to turn it over to James to go ahead and lead this part of the presentation.
Hi, everyone. Thank you for joining us today. Like Natalie said, we wanted to jump right in and address some of the most common questions we've been getting. Before we do that, I do want to say that things are changing very quickly in this area, and so we recommend that you check with legal counsel before addressing any COVID-19 or coronavirus-related issues that may come up at your company. Additionally, because each factual situation is different, we recommend that you check with your attorney before taking any action. A big question that we've gotten from our employers deals with sending employees home who are exhibiting COVID-19 symptoms and whether or not they can do that. The short answer is yes. Employers can send someone home if they are exhibiting coronavirus or flu-like symptoms. The EEOC has said that doing this is not a violation of the ADA. Just recently, actually, this past Friday, the EEOC put on a webinar where several EEOC lawyers talked about this issue even more. And they said that for employees who are coming into the workplace, employers are allowed to ask them if they have the virus, if they have any symptoms of the virus, or if they've been tested for the virus. And so employers can really ask employees about these issues if they are going to be physically present in the workplace. And then, as well as this says, you can definitely send someone home if they are exhibiting these symptoms that are typical of COVID-19 while at work. As it relates to getting these employees back into the workplace after they've been out for some period of time, whether it be for symptoms of COVID-19 or the flu, the EEOC has said that employers can request that employees returning to the workplace bring some sort of doctor's note saying that they're okay to return. However, the EEOC also advises that employers not necessarily require this at this time because there's a real chance or real fear of overwhelming the medical system. And the reality is a lot of people will not get in to see doctors if their symptoms are not severe enough. And so what we've been advising our clients is that someone who is experiencing symptoms, that they wait at least 72 hours before returning to the workplace, or 7 days from when they first started experiencing symptoms. And that 72 hours is 72 hours without experiencing symptoms without the aid of medication. And we're taking that standard, that guidance directly from the CDC, who has suggested that this is what employers do in situations where employees may be experiencing some symptoms. Anything to add here, Natalie?
The only thing I would add is that this is already starting to really become a big question for us because so many employees right now are calling in saying, I have a fever or I've started coughing, and I called the doctor's office and they said, do not come in. You're not going to get a test. Stay home. Treat it like you do have it. So we're going to have a lot of employees who are not actually getting into the medical system. If they do, go ahead and require that doctor's return to work notice. But I think we're going to see a lot of situations where they just don't get to see a doctor or have that access. So really look to the CDC for guidance on returning them to work. Absolutely.
And before we move on, I do want to say that as we go through, and Natalie said this, but please feel free to submit questions using the Q&A panel. It should be on the right side of your screen, and we'll try to get to those at the end. The next question is, can employers mandate testing and doctor's visits for employees? And we've been seeing this a lot as it relates to taking temperatures. The EEOC came out and said that employers can measure employees' body temperatures in an attempt to prevent the spread of COVID-19 in the workplace. Employers can also screen job applicants for symptoms of COVID-19. Really, these measures are aimed at stopping the spread of the disease in the workplace and taking precautionary preventative measures to do so. Like we previously discussed, the EEOC advises that employers not require employees to provide a doctor's note in the majority of situations. Like Natalie pointed out, it may not be possible for employees to get into a doctor, or they may be advised simply to stay at home. And so we really advising our employers to just follow that 72-hour, 7-day guidance set forth by the CDC. One thing I will note here is that employers want to be thoughtful if they choose to check employee temperatures and how they're doing that. For instance, are you going to have one employee take the temperature of all of the other employees? This may create an issue where the employee who's taking the temperature will, of course, be within 6 feet of the employees who are getting their temperature taken, potential exposure issues there, and then also the potential that the person taking the temperature may unknowingly transmit it to other employees, the employees whose temperatures are being taken. And so we really advise our employers, to the extent of doing this, think about the best way to do it so that you minimize the spread of the disease. Another thing is, in order to comply with certain OSHA and ADA legal requirements, we are advising that employers, if they choose to have an employee take the temperature of other employees, have the employee taking the temperatures receive some sort of training on that, whether that be simply reading the instruction manual or watching a video on how to take those temperatures, so that one, temperatures are accurate, and two, things are being done consistently among employees. Anything to add, Natalie?
No, I think that's great.
Question we've received a lot relates to potential absences that may arise from the coronavirus, specifically as it relates to sick leave policies, vacation leave, and medical leave. Where we advise our employers start here is that they look at their own internal policies to determine eligibility for sick leave and vacation time. Whatever you put in your policy is going to typically dictate these things as it relates to your employer-provided sick leave, vacation time, and other sorts of leaves that your employees may be eligible for. But here we also now have, with the passage of the Families First Coronavirus Response Act, some additional considerations, and we're going to get into these later. But there's now newly enacted leave time under the Emergency Family Medical Leave Expansion Act. We've shortened that as the EFMLA, and the Emergency Paid Sick Leave Act. And so employers also now need to be aware of those two new laws that go into effect tomorrow when making these decisions. Anything to add here, Natalie?
No, I think we'll get into it more in a little bit when we start talking about the new laws.
Sounds good. A big question that we've also received is, what information can employers share with other employees about a sick coworker? So let's say you have someone in your workplace who is exhibiting symptoms or perhaps even tested positive for the virus. What our employers want to know is, what information should they be and can they tell other employees, other coworkers who may have been in contact with this sick individual. Where we start is by saying that all information, medical information, should be treated as confidential. In the event that you know an employee came in contact with coworkers and may have exposed them, we advise that you tell those coworkers. We do not advise that you share the identity of the potentially infected employee. You may run into some ADA issues there if that's something that you do. We do also understand, though, that sometimes that may not be possible, that sometimes the identity of the infected person may be obvious, or people will easily figure it out. And what we've been telling our employers is, to the extent that we're balancing out everything, the privacy interests of the infected person may have to give way to the greater need to expose those, or to notify those that have potentially been exposed. And so, to the extent you're erring on one side or another, we err on disclosing this to employees who may have come into contact with an affected coworker. Employers should also notify the local health department. Local health departments have been great teammates, providing guidance to employers when it comes to dealing with COVID-19 issues. Anything to add here, Natalie?
No, I think that's right. Just keep in mind that some of those local health officials are getting overwhelmed. So it's possible you're not going to get that response, but definitely reach out.
Absolutely. They're doing the best they can, but just the high volume of cases that they've been dealing with. The EEOC in that webinar that I mentioned earlier also came forward and said, basically on this issue, you should contain the spread of confidential information to those who need to know. And so if someone doesn't need to know, then don't tell them. Another question we received are, what are issues that employers should consider when establishing telework policies? The number one thing that we recommend is reviewing your technology and IT capabilities, just to make sure that your company can adequately support teleworking. One thing that a lot of people don't think about, especially if their employees will be accessing confidential information, is that you want to make sure that any cybersecurity concerns are taken care of on the front end. When we're talking specifically about the employer-employee relationship, it's really important that employers set expectations up front. And so we recommend, one, having a policy on this, and then two, just communicating in that policy what it is that you are expecting from your employees, even though they aren't physically present in the office. A great example of this is if you expect your employees to be by their computer or by their phone, and in the event that you call or need something, then that's something that you should tell them. You shouldn't, there should be no surprises on that end. We also recommend that to the extent employees are working with confidential information, that you set forth how they're supposed to deal with and dispose of that confidential information. For instance, should it be your policy that nothing is discarded while they're working from home, and all these documents will be shredded later? Just something else to think about. And then as it relates to employer-provided property, we do recommend that you get some sort of acknowledgement from your employees that says, this property is provided by my company, it's for work purposes, and I agree to return it at the end. Anything you would add here, Natalie?
I think the biggest point to make here, and you probably already got a good sense of it just listening to James explain all this, it is an area where you do need to get into the weeds a little bit. It's important to really anticipate what are the things that are going to come up by the nature of what each person is doing as their job, and then try to get as clear guidance as you can on it.
All right, let's move to the next question. In the event an employee tests positive for COVID-19, what are an employer's reporting requirements? As we talked about just in the last slide, employers should definitely work with their local health departments. Local health departments have been providing assistance in helping employers determine next steps. And so in the event that someone tests positive for the virus, determining additional steps you should take, such as notifying employees and things of that nature. Like Natalie pointed out, these health departments may be overwhelmed, and so we recommend that you also just be prepared to follow CDC and OSHA guidance. OSHA has come forward and said that someone having the disease in your workplace triggers a reporting requirement that you notify OSHA. This isn't typical for all sorts of viruses and diseases, but for this specific virus, COVID-19, we are seeing, or OSHA has said that you should reach out and report that. And so what you really want to do, just in a nutshell here, is contact your local health department, report it to them, and then report it to anyone else you may have a legal requirement to do so, or a legal duty to do so. This includes OSHA and anyone else you and your counsel are able to identify. Anything to add here, Natalie?
No, I think you hit it.
Can employers restrict access to facilities, reduce hours of operation in response to COVID-19? The short answer here is yes. Many employers have already done this, specifically when it relates to closing business lobbies and then areas where customers, consumers typically patron your business. And so they've done this for two reasons: to both protect their employees and protect customers. We do also want to bring up here the fact that many states, many counties are now implementing stay-at-home orders. I'm sure a lot of you have already taken or looked at these and determined how they affect your business. But that's something else that you want to look at, another wrinkle to determine what exactly your obligations are to limit your business in the face of the coronavirus. Anything to add, Natalie?
No, I think that's fine. It kind of goes along with this about changing your hours and things for employees, though, is if you are going to reduce schedules or even reduce pay, there are a lot of rules implicated there, especially if you have exempt employees who rely on that salary basis test. So just flag that issue to make sure you look into those if you're going to be making these sorts of changes.
A big question that we've got from our employers is what happens if an employee gets sick and exhausts all available leave. And so we'll talk about this some later. But with the passage of the Families First Coronavirus Response Act, there's now a lot more leave out there. And so it's possible that if you're an employer who's covered by this law, that you will be required to pay either some sort of emergency family medical leave or paid sick leave. And so you should definitely look to those two laws to determine their eligibility to your employees. And then something that we're reminding our employers about that's a tool that they can use is an employer can permit an employee to remain away from work without being paid. That's something that you can do. I will flag here just for you to note that you'll want to look at your insurance benefits, because you may get into a position where, well, this person isn't working, your insurer may determine that they are then ineligible for benefits. And so that's something that you will have to determine on your end to make sure that you're compliant here. But generally speaking, employers can permit an employee to remain away from work, and that be okay. Anything to add, Natalie?
No, I think that's good.
All right. Well, with that, I'm going to turn it over to Natalie, and she's going to talk some about the new bills that are going into effect.
So the Families First Coronavirus Response Act is going into effect tomorrow. And it has two sort of sub-provisions. Actually, they have their own act names: the Emergency Family and Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. And we're going to talk about each of those separately so that you have a good understanding of what they're covering. And the Department of Labor has been actively publishing guidance on these. They started right away. They've put out little pieces as they've gone along. There may be some more today, but they've got a Q&A document that at my last peek at it had 59 questions and answers. So that is a good resource on the Department of Labor website that you can look to if you have some questions about how these acts play out. So the first thing that you need to know about them is there is a posting requirement, a notice requirement. You have to tell your employees about these laws. And that poster is available on the DOL website. There are two different ones, one for federal employees and one for private employees, so make sure you get the right one. But you may have a lot of people who are working remotely, and if that's the case, be sure you're getting this to them. So if they're not going to be where you normally post your notice, make sure you're getting it to them by email or something. And there is a little guidance document they have on those sorts of issues, given how disrupted everything is right now. So the first thing we're going to talk about is this Emergency Family and Medical Leave Expansion Act. it applies to all employers with fewer than 500 employees. That number is really, we've had a lot of questions on this. That number is determined by really looking at, are you a separate, independent entity that manages your own employees, makes your own decisions, all of those things independently. And if you are, even though you may be a subsidiary of a bigger company or you may have a lot of affiliated companies, you are probably going to be viewed on your own for looking at whether you have fewer than 500 employees. But there are a couple different standards that they've put out there in the guidance that you need to look at. So if you have questions about that, if you have affiliated entities, you'll want to look just to make sure you're counting correctly whether you're covered or not. Then if you have fewer than 50 employees, then there is a possibility that you don't have to comply with this act. You don't have to provide this leave. To do that, though, the viability of your business has to be jeopardized. Great news, DOL put out some guidance on this. It is not purely a financial focus here, but it can also be a focus on if you have just 2 or 3 key employees that can do certain jobs, and if they aren't there performing those jobs, you can't continue in business if you're a small employer, then that would be the type of thing that could show it would jeopardize your viability as a business, and you would not have to be providing this kind of leave. So you definitely want to look at those if you're a small employer and you have issues like that. Then what is it? Under this expanded Family and Medical Leave Act, all it does is says there is another reason that leave under the FMLA is provided. And it is this sole reason that employees are unable to work or telework, and that's important. If they can do the work at home or remotely, they're not entitled to this leave. And the reason that they would be is to care for a child whose school or daycare has closed. So if they're normally paying someone to take care of the kids, or the kids are normally going to school and now they can't, and because of that, the employee cannot work, then they would be entitled to this leave under the Emergency Family and Medical Leave Expansion Act. The employees that are qualified for it, they need to have been there at least 30 calendar days, and it does include part-time employees. So if you're an employer who's large enough to be covered under the regular Family and Medical Leave Act, you'll know that a lot of this is different. There's also an exception that can come up here if you are an employer who employs people that are healthcare providers or emergency responders. And the Department of Labor has put some definitions out there for us on those. And it's different. Normally under the regular FMLA, you think of healthcare providers and you think of the people who can write those notes that people need to be out of work. They have a serious health condition, and it's a pretty limited definition. And that's true, but under this, they say when you're looking at who's eligible to take the leave and who the employer can say I'm going to exclude from the leave, they change that definition. So pretty much if you're a doctor's office, anyone who's working for you could be excluded under this. So definitely take a look at those provisions and guidance from the Department of Labor. What is provided here? You can get up to 12 weeks of job protected leave. That is the same as under the regular FMLA. So if you're covered by normal FMLA, this is a cumulative 12 weeks. It's not an additional 12 weeks. So if you have someone who's already taken a couple weeks for their own serious health condition earlier in the year, then they only have 10 weeks of job protected leave left. It's a total. The leave under this act is unpaid for the first 10 days, but it's paid after the first 10 days. And that might seem odd, but there's a reason for it. Those first 10 days, the employee has an option to use other types of paid leave that might be available. So an employee could say, I have paid time off accrued. I want to use that to get paid during that unpaid period. Or they may say under the other act, the Emergency Paid Sick Leave Act, I want to get paid under that act for this first 2 weeks. And then after those 2 weeks, those 10 business days, then the leave becomes paid under the Emergency Family and Medical Leave Expansion Act at 2/3 of the employee's usual rate of pay up to a maximum of $200 per day, and then no more than $10,000 in the aggregate. Now, the employers, you get to recoup the costs of providing this leave, and we'll talk about that in a minute, but it's through some tax credits related to your payroll contributions. All right, I'm going to jump to the next one, the Emergency Paid Sick Leave Act. This also applies to the same types of employers, fewer than 500 employees. And if you have fewer than 50 employees, again, you can get out of this act possibly if it's going to jeopardize the viability of your business. And the provision that you can get out of is that paying for the child care under this. This applies to public employers regardless of size, and this is a key provision. It is in addition to any other paid leave that you already provide. And you can't require employees to use up what you provide as an employer before they take this type of emergency paid sick leave. You can, if you want, allow the employee to supplement this leave. So we're going to see in a minute that there are some portions of it that are at that 2/3 rate, just like under the other act, where you might be able to allow them to use paid leave they have to make up that difference. But generally, this is in addition to anything they have. The employees are entitled to this leave regardless of how long they've been employed by the employer. So that's an important difference between the expanded FMLA we just talked about and this paid leave. Because under the other piece, you had to have been there 30 days. Under this piece, you do not. What do they get? Full-time employees get 80 hours, up to 80 hours of paid leave. And the Department of Labor made it very clear what they consider a full-time employee to be, and that's someone who normally is working 40 or more hours per week. Everybody else is considered part-time under this act. And so they're going to get the average hours worked over a 2-week period. Again, employers get to recoup the cost of this. We'll talk about that in a minute. And the rate that the employee gets paid here, it's going to be the maximum amount they're entitled to receive depends on the reason for the leave. So it's at their regular rate of pay, but it depends on the reason they're taking it to determine how much they're actually getting. So we've got a little chart here for you. Under the Emergency Paid Sick Leave Act, there are 3 reasons that an employee could take leave that are based on the employee's own situation. And that's reasons 1 through 3 here. They're at the regular rate of pay, and there's a maximum, $511 a day, up to a maximum of $5,110. So these reasons, number 1, the employee might be subject to a federal, state, or local quarantine or isolation order relating to COVID-19. Department of Labor clarified something we'd all been wondering, which was, what about all of these orders that the states are putting out or that the local governments are putting out. The stay-at-home orders, or perhaps only essential businesses can be open, all those sorts of things. Do those constitute a quarantine or isolation order? And they do not. So an employee who is not working because you've been ordered as a business to close does not have a qualifying reason here. The second reason for an own employee is that they've been advised by a health provider to self-quarantine due to concerns related to COVID-19. So that's where you're going to see a lot of situations where we don't know if you have it or not, but the healthcare provider is going to say you got to self-quarantine, you've got to isolate because you've got some symptoms. Then number 3, the employee is experiencing symptoms that match COVID-19, and they're seeking a medical diagnosis. And again, we think this is going to get tough because more and more people are going to experience symptoms, but fewer and fewer of those people are going to be able to get in to see a medical professional. There are some great things going on as far as being able to video conference with a doctor and get some guidance, but a lot of times it's going to be a phone call to that doctor's office, an evaluation over the phone, and they're going to be told to just act like you've got it. Stay home. So you're going to get a lot of these situations that fall into 2 and 3 here. The other 3 reasons listed, it's at 2/3 of the regular pay with that same maximum you saw with regard to the expanded family and medical leave. These reasons relate not necessarily to the individual employee, but caring for someone who's under a quarantine or isolation order, or caring for a child whose school or daycare has closed. And then there's a catch-all. And the catch-all we just don't have guidance on yet. But the Secretary of Health and Human Services can issue guidance here telling us that there are some other situations that we think are so similar to the ones that have been listed that we're going to include them as well. They have that authority. We haven't seen any of that guidance yet, so we don't know what that will be. So a couple comments here. This reason number 5, the school closing, you can see that ties in with the added reason under the Emergency Family and Medical Leave Act. So the employee could decide to take this leave paid for that first 10 days under the other act, and then get the additional 10 weeks under that act, but it's all at that same 2/3 regular rate of pay. All right. Now, explaining how all this gets paid for. It's a little complicated, and we don't have the final guidance out there yet. I've seen a lot of commentators trying to explain how they think this is all going to happen. The only thing that we have that we're pointing out to is the March 20th release. It was a joint release by the U.S. Treasury, Department of Labor, and IRS, and they said, hey, this is going to work. We're going to make it work, and here's how we're going to do it, that the employers will be able to retain amounts of their payroll taxes equal to what they're having to pay out under these leave laws rather than depositing that. So that may mean it's just going to be a delay on when you have to pay those, but in the immediate short-term cash flow sense, you'll have access to that money. Then to the extent it doesn't cover it, then you can ask for a refund. And the IRS is expecting to give those refunds within 2 weeks. So that's how the initial reactions to all of these leave laws, I mean, we got calls as soon as they heard about the provisions saying, we can't afford this, we can't front this money. This is how they're trying to address that. It's not clear exactly how it will all play out, but the point they're trying to make by issuing this press release was that we're going to make it workable for you as much as we can and try to solve that cash flow issue. All right. Then they threw another law at us. And that is this Coronavirus Aid, Relief, and Economic Security Act. Everybody knows it as the CARES Act. And it's massive, and it has a lot of information in it and affects a lot of things. With respect to the two leave laws that we've been talking about, the CARES Act actually did amend them in a couple ways, most of them pretty minor, just creating some clarifications. But the one fairly substantive piece that we did see was a provision that talks about if you rehire people, because a lot of people before this had let people go. They'd done layoffs. So we got a little clarity on what it looks like when you rehire people and whether they'd be eligible here or not, especially with respect to that rule that said under the Emergency Family and Medical Leave Expansion Act that the employees had to be employed for 30 days. That rehire provision is targeted to make sure that the people who have been rehired pretty quickly are going to fall within this. So we've got that. We also have some direct assistance to households. You've probably heard of that. There are going to be people getting checks. There are limits on that, but that's out there. There is an expansion to the unemployment benefits. And we're going to talk a touch about the unemployment benefits, so I'm going to let James mention this. But we may have some questions on this one because it's been one of the strategy questions we've been getting a lot from clients about how to deal with. And then the other thing that I think for purposes of talking about employment that I want to flag in here, there are some tax credits and the ability to postpone your payroll tax obligations. Those two things are available to certain companies, mostly for employers who have had a financial hit. They've either been closed or their profits and things, their revenues have gone down substantially. You can get some tax credits based on your payroll. And then the other one about delaying your tax deposits is there. Both of those, though, say you cannot use those two provisions if you take out one of the loans specifically mentioned in this act, which is the Paycheck Protection Program portion of this act, because those loans have in them a provision whereby part of the loan is forgiven, and that loan forgiveness is based on how you're using the loan and tied very closely to your payroll expenses. Basically, if you're going to get this and we're going to forgive part of it, you have to keep your employees and you have to keep paying them at a certain level. So that's generally what's in that act. I'm going to let James go ahead and talk to you about the unemployment situation right now, and then we're going to dive into questions.
A lot of our employers have been coming to us and saying, if I lay off my employees, what are their options for receiving some money? And this is where we turn to the Unemployment Insurance Benefits Program. Here in North Carolina, Governor Cooper issued an executive order on March 17th that expanded the availability of unemployment insurance to those affected by the coronavirus. What this did was get rid of some of the traditional barriers that prevent some individuals from either qualifying for benefits or for receiving benefits as quickly as possible. So, for instance, the 1-week waiting period was done away with. Employees who have had their hours reduced due to the coronavirus became eligible for benefits. There's a lot of information that the North Carolina Division of Employment Security, that's the governmental agency that administers benefits in North Carolina, has posted on their website. Here's a link to that information. I advise you check that link out if you have information, or if you want to know more information about this. Just generally speaking, the maximum benefit amount in North Carolina is $350 per week. Under the CARES Act, there's going to be more money made available for unemployment benefits. The federal government has stepped in and said that they will provide an additional $600 a week on top of that, for a total of $950 a week potentially, to an employee who is either out of work or had their hours reduced. due to the coronavirus. I will note right here that not everyone will necessarily receive the maximum benefit amount of $350. And then traditionally, unemployment wages or unemployment benefits have been subject to federal and state income taxes. And so it's not necessarily $950 outright for each person. Important for employers, employers will not be charged for the additional money that's being provided to out-of-work employees. And so that was an important provision because otherwise employers would be on the hook. So just generally speaking, both the federal government and the state government are attempting to use the unemployment benefit system to get money in the hands of people who are out of work due to the coronavirus. So those are all the slides that we had prepared. We wanted to make sure that we left an adequate amount of time to address your concerns. So once again, I'm going to ask if you have any questions, please feel free to submit them using the Q&A section. Some have already come in, and so I'm going to start reading some of these. The first is someone's written that my understanding is that the following expenses accrued between government-enforced closure of business March 17, 2020 and June 30th, 2020 will be forgiven. Does this include contractors? I would like to hire extra staff. For example, sales director, is that allowed? I would also like to give myself a salary, which I have not taken before. Is that allowed? Rent, utilities, insurance, and other wages. So I'm going to say that I actually don't know the answer to this question, and I say that for two reasons. The first is to point out that Brooks Pierce has an entire team of attorneys working on these issues. It's not just Natalie and I, it is attorneys across various practice areas looking at various aspects of the bills and how they are going to affect your businesses in a variety of ways. And so I want to make that very clear that if you have a question about a different aspect of your business, please feel free to bring it to our attorneys. And I say that also because this bill is just expansive. The bills that have passed, the amount of provisions that are included in them, and we are also just waiting for a lot of guidance from various governmental agencies. Natalie, are you aware of these provisions?
So I think what is being referred to here has to do with the Paycheck Protection Program, where if you do take out this loan, there are some details about what you can spend it on. And then there are details about maintaining your head count, maintaining your payroll, especially during a particular 8-week period that is probably going to be determined based on when you get the loan. So that's very specific. We would be happy to get a team on a call with any of you who want to talk through this, because it's very, very fact specific, and a lot of it has to do with what your situation is. Has your business been completely closed? Are you still open? Do you still have your employees with you, or have you already laid them off? There are so many factors that go into this. And then analyzing, is the Paycheck Protection Program best for you, or would the other credit options be best for you? There's a lot there. So absolutely need to dive into these, and you need to do it fairly quickly. But the first conversation you might want to have and figure out is, what can I afford? Where am I in this process? And then what are my goals? I've talked with employers whose goals are, I want to figure out how to get the most money in the pockets of my employees. And so then that becomes pulling into play this extra $600 in unemployment and how that could play out. Do I get this loan so I can pay them? It's very complicated. So we appreciate the question. Sorry that we can't give you a direct answer on it, but we're happy to get a team together and talk with anybody who wants to give us a call.
The next question that we received reads, I read in one article that the new FMLA paid provision does not apply if the stay-at-home order is in effect. And so what the Department of Labor has said is that if the reason, or if your business has to close due to one of these stay-at-home orders, that is not typically a qualifying reason for your employees to receive emergency FMLA leave or emergency paid sick leave. And so in those situations, and of course it depends on the facts of your situations, but just broadly speaking, employers won't be on the hook to provide benefits.
Yeah, I agree with that response, James. It really comes down to why is the person unable to work or to work from home? Because these leave laws only come into play if both of those are true. You can't go to work at your workplace and you can't work at home or remotely. And so then they set out the reasons that would qualify for these leaves. None of the reasons that are listed there include the business is closed. So if you're closed because of one of these orders, that's not a qualifying reason under these new laws. If business has decreased so much that you've had to furlough people, that's not a reason. A furlough isn't a reason under one of these leave acts. And the Department of Labor has clarified, just like under the regular FMLA, that it's job protected, but if this would have happened to you even if you had been actively working, it can still happen to you even if you're on one of these leaves under either part, the Paid Sick Leave Act or the Expanded Family and Medical Leave Act. The point is, if you get to a point where I have to let everybody go and you currently have people out on these paid leaves, if you don't have the money anymore and you have to let everybody go, you can't pay them even with the tax credits and pay the rent on the building and everything else that you've got, and you have to let them go, that paid leave stops when you let them go. Now, you can't let them go because they took this paid leave, but if it would have happened anyway, regardless of the circumstances, and they happen to be out on this leave, it doesn't provide them greater protection than being at work and whatever it is happened.
The next question we received, is it possible to have some employees sit out of work and take advantage of the Families First payroll tax reimbursement? The idea is to have rolling workforce reductions to help the company financially. Natalie, I'm going to let you tackle this one.
Okay. So this is tricky, but I think the answer is probably yes, if the reasons actually apply. So if what you're saying is we can't afford to pay everyone, and therefore we're going to have alternating work weeks, so half the team will come this week, half will come the next week, or maybe part of them come Monday, Wednesday, Friday, whatever the case may be. The reason that they can't work doesn't sound like it's one of these reasons listed under these acts. Rather, it sounds like you don't have the financial ability to pay everyone, or you don't have enough work for everyone to be there at work. So the answer is yes, if the actual reasons fall under these acts, but no, if it's we're trying to just have some people work half the time so that everybody's getting some pay from us. But no, you're not going to be able to get the tax credit for paying people to not work if the reason is you don't have enough work for them. They're going to have to turn to the unemployment system for that.
The next question is there any documentation HR can use to determine eligibility for tracking purposes? I'm happy to start this one off. The Department of Labor has issued some guidance in the FAQs that Natalie referenced earlier that talks about documentation for purposes of the Emergency Family Medical Leave Expansion Act. Just a reminder, the EFMLA, the sole reason that you can qualify for this type of leave has to do with caring for your child because their child care facility is closed for coronavirus-related purposes. The Department of Labor has said that employees should provide some sort of note or documentation that they received from their child's school or daycare, and provide that to employers. As it relates to the paid sick leave, currently I'm not aware of anything that has, or any guidance that has been issued referring relevant documents that need to be gathered to determine eligibility. But this may be something we see something from the Department of Labor on in the near future. The next question we received: if the kid's school is closed, making them eligible for FMLA, but school would have normally closed in May for the summer, do they remain eligible? I can start this one off as well. The emergency FMLA benefits last to the end of the year. And so it's important to remember that even though we do have school closings coming up in May or June, that this may be an issue that, depending on when this virus subsides in our communities, that we have to face when school resumes in August or September. And so that's the first thing to remember. And this question raises a really interesting point. And just thinking outside the box here, the language that's used in the EFMLA, and please correct me if I'm wrong, Natalie, but talks about your child's normal providers. And so, for instance, if your child were to be normally enrolled in summer camp, and now they can't be enrolled in summer camp, there may be an argument there that perhaps that would be a qualifying event.
I think you're absolutely right, James. I think it would. Yeah.
And I haven't seen any direct guidance on this. It's just me thinking outside the box. But this may also be an issue that we see more guidance from as this becomes more timely, as schools, get ready to put students on summer vacation. So our next question: what if an employee has the ability to do his job as a telecommuter but feels he cannot do the job and properly take care of a dependent? Natalie, I'll let you jump in here.
Yeah, so there is, this is going to be an issue for people. Number one, I would say we've been in this situation for a little while now. So if you have people who are already teleworking, and now that these leave laws come into play, they suddenly want to say, well, I can't, I'm home with my child and I can't do it, and I want to take advantage of these laws now that I could get paid for not working. I think it's fair and reasonable to say what has changed, okay, and try to understand why it's different now, because it looks strange. But they may very well have some good reasons, and it may be something like, we have tried this, but I can't get anything done because my child needs help being able to do these remote things that they're being asked to do. I'm constantly getting interrupted and I can't do it. What the DOL guidance is saying is you need to work together, the employer and the employee, and try to figure it out. So if the employer could have some flexibility and say, well, you don't have to do the work from 8 to 5. Let's see what we could arrange. So that kind of flexibility might get there. But the bottom line is probably if there are situations where the employee can't get in the full number of hours because of this, or just simply can't do it, you're probably going to have to provide it. Also keep in mind it's going to matter here whether your employee is an exempt salaried employee or not. because if they are, you've got to go through those issues very carefully. Because you'll recall, to have someone who's exempt, that salary basis test, it basically says you can't be deducting from their pay. And so if they're only able to work part-time now, what is that going to look like and how does that interplay? If you've got those complex situations, we're really recommending that you reach out to us and we talk through those one-on-one, what those are going to look like and how you need to carefully structure those payments to not get caught on those issues.
So we're right at an hour right now. I see we have a few more questions. We'll try to get through as many as we can as quickly as possible, but we do want to be respectful of your time. The next question that we have is, what would be general guidance for a self-employed real estate agent who has a sub-S set up to receive commissions and then receives a salary from that sub-S? This sounds like a very specific factual scenario, one that we would be more than happy to talk to you about if you give us a call, but it's hard to just provide general guidance. Let me see if I can get through some more questions. Do you know whether required minimum distributions from the company retirement plan need to be disclosed as pension/retirement pay for unemployment benefit purposes? This is not something that I know off the top of my head. It's an issue that we would be happy to look into for you. I will say generally, and I know that we received another question about unemployment benefits from someone out there, is generally in order for someone to be considered unemployed such that they will receive benefits, they can't be receiving any sort of other employer-provided benefits, such as paid employer sick leave. Depending on how your vacation time policy is structured, that may also disqualify your employees from receiving unemployment benefit payments. The other question that was posed was asking whether or not it's appropriate to have employees file for unemployment but then continue to work at home. And so I'll talk about these two questions together since they both dealt with unemployment benefits. In North Carolina, an employee can be considered partially unemployed. There's a special threshold that the government looks to determine whether or not someone's hours have been reduced enough that they would be considered partially unemployed and therefore entitled to benefits. And so the thing you have to consider is, well, how much has that person's hours or that person's working capabilities been reduced? That's what you need to look at to determine whether or not they're still eligible for benefits. You also have to look at, well, how much are they earning when they do work? There is a maximum amount of wages that someone can earn in a given week and still receive unemployment benefits. And if they're a high wage earner, it may be possible, even if they're working 2 hours a day, 2 days a week for, let's call it 16 hours, that they're still earning more money, or enough money, I should say, that they'll then be ineligible for benefits. And so these are very fact-specific inquiries. And so to the extent you have questions, we do encourage you to contact us. And there's one more question that I'm seeing here. And Natalie, I'm going to ask if you would handle this one. The question reads, did you say that if we get one of the loans with the CARES Act, that we do not also get the tax credits with regard to the EFMLA or EPSLA? And this person...
Oh, yeah, that's a good question because that was a little confusing. No, that's not what I'm saying. I'm saying under the CARES Act, there are a lot of different ways that businesses are getting relief. And there are some tax credits under that act that you cannot take advantage of if you get one of these Paycheck Protection Program loans. But that is the CARES Act is separate and apart from the Family First Act that we're talking about that has the Leave Act and the leave laws in it. And so the credits that are available for providing this leave, those are available to you. They did not take that away under the CARES Act. It's some different types of credits that are completely separate and apart from whether you're providing this leave, that you can't have both of those under the CARES Act and the Paycheck Protection Program loan.
I believe those are all the questions that I'm seeing on my end. Are you seeing any more on your end, Natalie?
I'm trying to look. I think so. I think we've got it. If you've put a question out there that we haven't answered, two things. One, if it's super specific, we would probably have avoided it because we can't answer it, can't really provide you actual legal advice during our webinar. And the other thing, it's possible we've missed one, so do reach out to us if you think it was a more generalized question and we missed it. And thank you all for your time. Glad to have you today.
Thank you.